straight ahead on Law and Crime Daily.
Boiling Mama's head down in the pot on the stove in the kitchen.
A gruesome scene as a Tennessee man is tried for allegedly stabbing and dismembering his parents. His own notebook holds key evidence.
Also, a Texas sheriff is under arrest, charged with tampering with evidence in the death of a man in custody who said he couldn't breathe.
And a judge orders grand jury records open to the public in the death of Breonna Taylor. Law and Crime Daily covers court cases from coast to coast.
And welcome to Law and Crime Daily, everybody. I'm Aaron Keller, along with Brian Buckmeyer and Terry Austin. Prosecutors are presenting evidence for the second day in the trial of Joel Guy Jr., a Tennessee man accused of stabbing his parents to death, even cooking some of their body parts on the stove over Thanksgiving weekend. The testimony centered largely around forensics. Law and Crime Daily's Brian Buckmeyer explains. Brian?
Prosecutors say Joel Guy Jr. planned for weeks to kill his parents and get rid of their bodies. Some of the details of how they say he did it are especially disturbing. Jurors saw crime scene photos, including this pot. Lisa Guy's head was discovered inside. Blood splatter covered the walls and bloody shoe prints led through the home. One investor called it a lot of movement. Professor of forensic Joseph Scott Morgan reviewed the victim's autopsy and tells Law and Crime he was surprised at the death of the defendant's alleged preparations.
He's utilizing a method, essentially, that we would use in forensics, where you would take the head off, put it into a pot, and you don't need an agent or anything like, an acid. You just place the body in water and put the head in water and turn it at a very slow or a very low temperature and kind of slowly allow it to heat. And so that's a very curious thing. I'd like to know how he came into that knowledge. What kind of pushed him in that direction to use that methodology, because there are a number of ways he's trying to utilize here. We've got cutting of the body, rendering down of the body with acid, and now we have this gruesome scene of him actually boiling Mama's head down in the pot on the stove in the kitchen.
And now to Terry Austin with how the sheriff's office says they were able to link the defendant to the killings of his parents. Terry?
Well, crime scene investigators combed the house looking for any clues the suspect left behind. They took swabs from knives, shoes, and door handles, but what might be most damning for the defense was what the authorities found on items the state says the defendant used to clean up the murders.
The first particular case, I developed it with black powder, lifted 2 prints, and took them in and entered them into AFIS, the Automated Fingerprint Identification System, and got a response back. That was from the Clorox glove package. The second print was actually on the same card. It was a double impression where the individual had touched it twice in almost the exact same place.
Okay, so how many fingerprints in total were you able to positively identify Joel Michael Guy Jr. As the owner of those prints?
6. And the latent print is on the left-hand side. The known print is on the right side. All the green dots represent corresponding ridge endings and bifurcations that are consistent on both prints as having come from the same source.
And one of the officers who testified earlier in the case describes the initial discovery of the shocking evidence.
Do you see anything once you get to the top of the stairs?
Yes, sir. When I get to the top of the steps, I believed it to be a human hand or a hand lying at the very end of the hallway.
Okay. And did you go a different way or have cause to go a different way than Detective McCord did initially when you're clearing the residence?
Yes, sir. Detective McCord broke off immediately to the right and kind of behind where I was, and I continued down the hallway.
Okay. And where you think you see hands, do you eventually make it to that room, sir?
Yes, sir.
And do you clear that room?
Yes, sir. Partially. Yes, sir.
And if you would, describe what you see in that room.
I see a human hand. It was lying in an upright position with another human hand that was closed fist behind it.
And after you make those observations, what do you collectively do as the officers who are clearing the residence?
Detective McCord had seen something in one of the other rooms and requested that we back out at that point. And at that point, we worked our way back out of the residence. And I went, if you were facing their residence, I went to the outside, far back right of the residence and held a perimeter till we could get additional officers on scene.
And still ahead on Law and Crime Daily, we'll show you pages from the notebook prosecutors say defendant Joel Guy Jr. used to plan the killings. And later on, updates in the police shooting death of Breonna Taylor. Why the public is about to learn a lot more about what happened behind the closed doors of the grand jury proceeding. Law and Crime Daily will be right back. We're back now to the trial of Joel Guy Jr., where the state said during opening statements that they have evidence from the defendant's own hand that these gruesome killings were planned.
Well, good morning to our jury. Thank you once again for being here today.
Prosecutors say defendant Joel Guy Jr. kept a notebook of plans for his murderous plot, from killing to clean up to cover up. Killing, get knives, quiet, multiple, get sledgehammer, crush bones. Get carving knives to make small pieces. Bring blender. Why make this a stabbing? He worries that he will be seen buying bullets. So the plan became kill her with knife, take dog with you, place her in shower, turn on hot water and point at her to get rid of forensics, remove her clothes and take them with me for disposal. Get rid of bodies inside house, there and my DNA already there. Flush chunks down toilet, not garbage disposal. He needs to be blended, not intruder. Get plastic sheeting for disposal purposes. Elsewhere, he writes, bring blender and food grinder, grind meat, and get bleach, he wrote. The defendant seems to have been trying to make it look like his father killed his mother and ran off. Cut off his arm and plant his flesh under her fingernails. Place her hand with his DNA so that his DNA is not washed away by shower. Ultraviolet light shows fingerprints. Check mail before leaving. To get rid of blood, use peroxide for hemoglobin and bleach for DNA. But might the police catch him? Body gives time of death, the defendant worried, with an arrow to alibi. Don't have to get rid of body if there is no forensic evidence on the body. Destruction of bodies, one note says, and it lists the composition of the body. The bleach, he thought, would denature proteins. Get plastic bin for denaturation process. Does not matter where they're killed, just get rid of bloody spots to prevent evidence of time of death. Place him in plastic bin and use it to get him into the upstairs bathroom. What about the getaway? Leave through front door and wipe down doorknobs. Timer for flammable set for Friday at 10 a.m. Sunlight masks fire, but not smoke. Everyone at work, so they can't report it. The defendant had a motive, prosecutors say. Relatives testified the victims were planning to retire and live on a pension and wouldn't have enough money to pay for their son's apartment.
She had stated that they were going to retire and it was time for Joe Michael to stand on his own 2 feet. He was an adult.
And does she discuss her future plans on whether or not she could help support her son?
She said that she couldn't do that no more, that he needed to be on his own.
They said that they were going to wait till Christmas to talk to Joel Michael, that they were going to have him to start paying his bills and stuff.
Okay.
They had said that they were retiring and that they were moving to Sikoransville, and that Joel Michael was going to find a job or need to find a job because they were no longer their money when they sat down and determined even down to the amount of beer that they drink a week and the amount of cigarettes that they have a week, what amount of money they would need, and that amount of money was what they had to retire.
During a proffer session outside the presence of the jury, the defense asked an important question on cross that would have played straight into the prosecutor's hands had the jury heard it.
Your brother, he stated that he had already cut off his son, is that right?
Yes.
Okay. And as to your sister-in-law, she told you she was planning to cut him off at Christmas. Is that right?
Yes.
The defendant's own notes seem to corroborate that he knew he was about to lose support from his parents. Assets, her life insurance, possibly more with double indemnities. With him missing dead, I get the whole thing. He's not alive to claim her half of the insurance money. All mine, $500,000.
So, Terry, this seems like a strong case for the state, in my opinion, at least. And I realize we're just in the state's portion of the evidence. But when you take these handwritten notes into consideration here, I should say, this looks like premeditation.
Absolutely. I don't think you could get a stronger case unless the defendant himself went on the stand and said, I murdered and slaughtered my parents. We have overwhelming circumstantial evidence. We have the motive, the opportunity, the means. And to your point, we have a handwritten note that shows premeditation. So there is no question in my mind that this case is a slam dunk.
Brian Buckmeyer, you're used to taking the pressure like this. Public defender, what's the defense?
I don't think this defendant really has a defense or is employing one, at least through this defense counsel. Really, they're just holding tight to the burden of proof. But if I'm about to take this case on, I've got to somehow show that that book has no connection with my client, whether it be writing analyst, and then also try to shift that motive to maybe another sibling, because if my client didn't really know he's going to get cut off, a lot of other siblings seem to know that.
So, Terry, remember, this is a case where the defendant has asked the judge to put him to death, bizarrely, if he's convicted. We're almost forgetting that element of this as well.
Well, that's right. And that shows some culpability of guilt, because he is saying, I'm guilty, please put me to death. I don't want to have a life sentence or anything less than that. So I think if the jury had that information, obviously that would make sure that he was convicted as well.
Rarely does this happen, Brian, but we oftentimes see a story behind a story. And in this case, it seems like there might be one. We heard a little bit more on the proffer sessions than the jury ultimately heard as to this financial motive.
Yeah, it's something that the prosecution doesn't have to prove, because you don't have to prove motive, but it's definitely something that's going to directly point circumstantial evidence to the defendant.
When prosecutors have motive, they love to use it. And coming up after the break, a federal appeals court forces prosecutors to eat their own words. We'll tell you how a trial went drastically wrong for the state of California. Plus, a Texas sheriff is under arrest by his own department over his handling of the in-custody death of a man who said he couldn't breathe. Learn how the sheriff is fighting back after the break. A New Hampshire couple is under arrest after a wife told authorities her husband shot and killed her lover and then ordered her to chop off the dead man's head and bury it separately from the body. Brittany Barron is charged with falsifying evidence. Armando Barron charged with capital murder for allegedly killing the lover, with assault for allegedly beating his wife during the ordeal. On top of that, the body of the victim, 25-year-old Jonathan Amaral, was left alone for 4 days, authorities say. A Texas sheriff and a government attorney are both under arrest for allegedly tampering with physical evidence in the in-custody death of a man last year. Body camera footage shows police tasing Javier Ambler 4 times as he told officers he couldn't breathe and couldn't comply with commands to put his hands behind his back. Ambler's death occurred while photographers from the former A&E series Live PD were with the officers. A&E says Live PD never aired its own footage and that the authorities never asked the show to hand it over. An ethics disclosure on our behalf, the founder of the Law&Crime Network, Dan Abrams, was the host of Live PD, and A&E owns a portion of the Law&Crime Network. The sheriff's attorney says the arrest is a political stunt leading up to an election, and that the evidence he's accused of destroying was of no significance to the factual determination that the officers did nothing wrong. A California murder convict will receive a new trial because the prosecutor who tried him botched the law. The Ninth Circuit Court of Appeals ruled that a closing argument presented by a state prosecutor violated the defendant's constitutional right to due process when the prosecutor said the following: "This idea of this presumption of innocence is over. Mr. Ford, the defendant, had a fair trial. We were here for 3 weeks where he gets to cross-examine witnesses, also an opportunity to present evidence information through his lawyer. He had a fair trial. This system is not perfect, but he had a fair opportunity and a fair trial. He's not presumed innocent anymore." Brian, the beginning of the prosecutor's statement and the end of it especially were the words the court had a serious problem with here.
Because it's incorrect. The presumption of innocence is maintained until the jury decides that the evidence has been proven beyond a reasonable doubt. So if you're saying that at summation, and especially if this is a jurisdiction where the prosecutor goes first and the defense goes afterwards, this is a mistrial. This isn't just, well, the judge is going to give a curative explanation. That bell has been rung. A jury has already heard that. And when you think about how this case ended up so divided, it's more than a harmless error.
The jury was up and down. They were hung for a while. They came back with an oddly split verdict in this case, Terry. So how could the prosecutor have avoided the issue? Thank goodness there was an objection there, but how could the prosecutor have handled the issue? Should the prosecutor have just simply not gone anywhere near the presumption of innocence here?
Well, you know, what you have to do in your summation, Aaron, is you can repeat the facts that went into evidence, and you can talk about the law that you know the jury will be instructed upon, what the judge said. What you cannot do is what was done here, which is to mischaracterize the law. As Brian said, the defendant is innocent until proven guilty. And by mischaracterizing it and saying that, you know, he no longer has that presumption, he stepped over the bounds.
Now, Brian, I know you would also have made a timely objection in a case like this. And the sad thing is it wasn't granted at the trial level.
Timely objection, table flipped over. Yeah, sure, tomato, tomato, Aaron. But you've got to preserve the record. And thankfully, that's what the defense attorney did here to allow the Court of Appeals to come to this right decision.
There certainly was a right way for prosecutors to say, we believe we have met our burden. That is a totally different thing than what was said here. We'll watch the case to see if it gets appealed up the chain any further. The next stop would be the Supreme Court. Let's check in now with Chief Investigative Correspondent Brian Ross with a look at what he's working on this week.
Thanks, Aaron. Coming up this week on Brian Ross Investigates, former Playboy playmate Karen McDougal was paid $150,000 not to talk about an affair the White House says never happened. But now she's talking with us, saying she's asked for God's forgiveness for her sins for having an affair with a married man. Do you imagine Donald Trump has in any way repented?
To be honest, I doubt it.
Plus, the president's taxes. We'll talk with Pulitzer Prize-winning journalist David K. Johnston. He's been tracking Mr. Trump's finances for years. That's coming up this week on Brian Ross Investigates, Aaron, on the Law and Crime Trial Network.
And when we come back here on Law and Crime Daily, an officer enters his plea after a grand jury hands up an indictment related to the police shooting of Breonna Taylor. That is when Law and Crime Daily returns right after this. The only Louisville, Kentucky officer indicted in the Breonna Taylor case has pleaded not guilty to a count of wanton endangerment. Now fired Detective Brett Hankinson was indicted on 3 charges for shooting into an occupied apartment next to Taylor's. Hankinson was arraigned in a hearing via telephone and was ordered not to have any firearms. He's currently out on a $15,000 bond. A judge has also ordered the recordings of the Breonna Taylor grand jury proceedings to be made public. That ruling came after one of the grand jurors filed a motion asking as such. Protesters took to the streets after the announcement of the grand jury's indictment. An attorney for one of the jurors said they want the proceedings released so that truth may prevail. The attorney cited great public interest in arguments for why the jurors should be allowed to speak freely. Here's some of the jurors' arguments. The citizens of this Commonwealth have demonstrated their lack of faith in the process and proceedings in this matter and the justice system itself. Using the grand jurors as a shield to deflect accountability and responsibility for these decisions only sows more seeds of doubt in the process while leaving a cold chill down the spines of future grand jurors. The juror specifically cited the Kentucky Attorney General's own words at a press conference following the indictment of the one officer. Here is what the AG said at the time.
Grand jury proceedings are secret, and so I'm not going to get into the specifics of details about that proceeding. What I will say is that we presented all of the information, and they ultimately made a determination about whether to charge. In this instance, they decided to indict Detective Hankinson. Well, what my role as the special prosecutor in this case was to provide the information and facts to the grand jury. Detective Cosgrove and Sergeant Mattingly were justified in returning fire because they were fired upon.
AG Cameron responded to the judge's order to release the grand jury recordings this way. We stand by our belief that such a release could compromise the ongoing federal investigation and could have unintended consequences, such as poisoning the jury pool. Despite these concerns, we will comply with the judge's decision to release the recording. So, Brian, does the AG have a valid point here? Can he turn around and say, well, there's other investigations this might jeopardize? What about the investigation you just completed?
He does have a point, right? You don't want to taint any future jury pools. However, this case has been going on for over 100 days. Any jury pool that might have been tainted, surprise, surprise, it already is. People have decided what the facts are already. However, his words as to how he describes the grand jury process raises more than a few eyebrows and suggests that he did not do this properly.
Okay, so Terry, the grand juror who filed this paperwork in court to basically get these things out in the public seems a little bit more worried about transparency than he or she seems to be suggesting a specific cover-up. Is that a proper way to read this?
I would read it that way because not only is this juror talking about transparency or looking for it, but so is the community. So when you have, as Brian said, a case that takes so long, and when you have charges that don't even relate to Breonna Taylor, the one person who was killed, people want to know what exactly was presented to that grand jury. They need to have transparency because the specifics of this case are so bizarre.
So, Brian, the AG is turning around saying, okay, I will comply, I will comply. What would happen if he didn't?
Contempt. It would be a legal battle. This isn't complying like, oh, I'm choosing to do this. This is complying like your mother told you it's time to go to bed and you have to do it. Like, he can't do anything else.
He can't sit up and say, well, I still want to read my comic books. I mean, you know, look, Terry, he's got to release this. The bottom line is we will have a lot more answers starting tomorrow about this process.
Yes, that's true. And you know what, Aaron? Most of the time, the grand jury proceedings are not released. But here you have the fact that they have to be. And so, you know, we're going to see what happened and we're going to see exactly what was presented.
Exactly. Terry Austin, Brian Buckmeyer, thanks for the analysis. Thank you for joining us here on Law and Crime Daily, where we discuss justice in America. We'll see you next time.
I'm Dan Abrams, and this is the Law and Crime Network.
The only 24/7 network with expert legal analysis and gavel-to-gavel live trial coverage. Watch the Law and Crime Network today.